All right, it's recording.
All right, I'm going to call the public hearing of the Sentencing Guidelines Commission meeting to order. I have a little script to read through, so I'm going to go ahead and get started with that. So good afternoon and welcome. My name is Kelly Lynn Mitchell, and I'm chair of the Minnesota Sentencing Guidelines Commission. It's now 1 o'clock, and the July 17th public hearing is called to order. This hearing is taking place in the Afton Room at the Department of Corrections Central Office at 1450 Energy Park Drive, St. Paul, Minnesota. I'm here along with Commissioners Middlebrook and Mazzaros. That's those there, and Director Nate Wrights. Those individuals are here in the room with me. Additionally, we have some commission members who are joining online, and that's Commissioner Fraze, Commissioner Saxena, Commissioner Moore, and Vice Chair Larkin. And Commissioner Morin, Commissioner Ladd. So those are the commission members who are in attendance today. The public hearing is being held to consider proposed modifications to the 2024 Minnesota Sentencing Guidelines and commentary resulting from the Commission's review of the 2025 regular session laws and technical modifications to improve the sentencing guidelines. So before us, we have Part A, which includes legislative amendments to new crime laws affecting the sentencing guidelines that were passed during the 2025 regular session and are effective August 1st, 2025 and January 1st, 2026. We also have Part B, which includes other conforming amendments to crime laws affecting the sentencing guidelines from the 2025 regular session that goes into effect on August 1st, 2025. And then Part C includes technical amendments to the sentencing guidelines, and those will also be effective August 1st, 2025. You may access a complete copy of the proposed modifications on our website at mn.gov/sentencing-guidelines-meetings. These have been available on the public website since June 16th, 2025, the same day that notice of this hearing was published in the State Register. There are a limited number of inspection copies available in this room together with website access information.
Commissioner Mueller was on as an attending.
Oh, I missed the fact that Commissioner Mueller is also attending today. So I just wanted to say that for the record. All right, so here are the public hearing procedures. If you wish, you may make spoken or written statements today regarding the proposed modifications. You may also address questions about the proposed modifications to the Commission, its staff, or witnesses. And if you make a spoken statement, the Commission or its staff may ask questions of you. If you would like to testify about the proposed modifications today, you must first register your name, address, telephone number, and the names of any individuals or associations that you represent in connection with the hearing. It doesn't appear that we have anybody here in person. For anyone who might be attending remotely, please email your registration information to staff at sentencing.guidelines@state.mn.us. Do that right away. You'll receive the meeting access information. And if you have trouble, you can also call our staff at 651-296-0144. After everyone has testified, the public hearing will end. The Commission will hold the record open for up to 5 calendar days after the public hearing to accept written comment. Written materials must be received no later than July 22nd, 2025. Any person who wishes to provide a written statement may do so in one of 3 ways: by delivering a written statement to the public hearing today, by sending the written statement by United States mail to the Minnesota Sentencing Guidelines Commission at 658 Cedar Street, Suite G58, St. Paul, Minnesota 55155, or by emailing the written statement to our email address, which is sentencing.guidelines@state.mn.us. The commission will give due consideration to all written comments received within the 5-day comment period, as well as all written comments received up until now. The commission will meet next Thursday, July 24th at 1 p.m. to finally adopt or reject its proposals. That meeting will take place in this room with remote participation optional. One person, Director Nate Wrights, has registered to testify today. So I'm going to go ahead and turn it over to Director Wrights and ask him to present his testimony.
Good afternoon, Madam Chair and members of the commission. My name is Nate Rice, your Executive Director, and I appreciate the chance to speak with you today about your proposed 2025 amendments to the sentencing guidelines. After further reviewing and researching your June 14th amendments, which you adopted upon my recommendation, I now have two focused sets of improvements to suggest that will enhance clarity, accuracy, and alignment with legislative intent. First, I now recommend treating the new fentanyl exposure offense as entirely separate from the existing methamphetamine exposure crime. Although both crimes involve chemical exposure, they serve distinct public safety interests. The methamphetamine provision protects both vulnerable adults and children and reaches not only methamphetamine itself, but also its chemical precursors and waste products. By contrast, the new fentanyl offense protects only children and focuses solely on fentanyl and its direct analogs. To avoid confusion and ensure each crime's unique scope is clear to practitioners and the public, I now believe the guidelines should list these as two distinct offenses with separate names. In addition, I now recommend that you add the new fentanyl exposure crime to Section 6's permissive consecutive sentencing list, consistent with how we treat the existing chemical exposure offense involving methamphetamine. My second set of recommendations addresses the mandatory consecutive sentences for assaults on sheriff's deputies by jail inmates under Minnesota Statute Section 609.2232, new paragraph B. My earlier recommendation relied on two misunderstandings about the new law. First, I mistakenly treated every assault under paragraph B as requiring a prison commitment. In fact, while paragraph B bars a stay of adjudication or imposition for assault in the 1st through 4th degree, only the 3 numbered clauses of paragraph B mandate an executed prison sentence. Second, the staff drafted language changing consecutive sentencing policy was written too broadly for the new statute. Clauses 1 and 3 are either already covered by the existing guidelines or do not require consecutive sentencing. The new language for Section 2F1A13 should only cover Clause 2 and must explicitly incorporate Clause 2's requirement that the assailant received an executed sentence for a crime the assailant was in custody for at the time of the assault. My written remarks contain new guidelines language that corrects both of these errors. By making these targeted corrections, separating the fentanyl exposure offense and clarifying the scope of mandatory consecutive sentences for deputy assaults in jail, the Commission will ensure the guidelines clearly and accurately reflect legislative nuance and are easier to apply in practice. Thank you for your consideration. I welcome your questions.
All right, are there any questions from members of the Commission? Commissioner Moore.
Thank you, Madam Chair. Director Wrights, are you able to hear me?
Yes, sir.
Do you have written versions of these proposed corrections for us to take a quick look at, assuming you're looking for some action or response?
Madam Chair, Commissioner Moore, the purpose of my testimony is to authorize you to take action next week. I did provide a copy of the proposed language to commission members earlier today, and I expect that will be posted. Another version will be provided to commission members today when I send out the meeting materials for next week. That will include the proposed language, and that language will be posted on the website for the public to be able to peruse either today or tomorrow at the very latest.
Thank you.
Any other questions for Director Wrights? Commissioner Middlebrook.
Thank you, Madam Chair. Director Wrights, I've got a question on your proposed language on the presumptive consecutive. Doesn't it also cover B2?
Well, there's permissive consecutive language that would cover B2 right now. And our previous draft had accepted that out. But right now, the existing presumptive consecutive language is really focused on people who are serving executed prison sentences, which is B1. But it doesn't cover people who are in jail. So under the new statute, under clause B1 covers people who are in jail somehow serving an executed prison sentence. Perhaps the prisons are full, or perhaps they were writted out for some reason and they're in a local jail and they assault a sheriff's deputy. And that's already covered under the existing guidelines presumptive consecutive sentence policy, because somebody who's serving an executed prison sentence and who commits an assault while in prison will be looking at a presumptive consecutive sentence. What's not covered, though, is the new clause B2, which applies to a defendant who was in jail, possibly pre-conviction, so certainly pre-sentence. So they haven't been committed to the Commissioner of Corrections yet. But I'll just give a hypothetical. Let's say somebody's in jail awaiting trial on a criminal vehicular homicide charge. While they're in jail waiting trial, they assault a sheriff's deputy. Then the next thing that happens is they are convicted of criminal vehicular homicide and committed to the Commissioner of Corrections. Then they're sentenced for the assault on the sheriff's deputy. That's what's covered by the new clause B2. And that's what the new language is trying to cover. So that would now be a presumptive commit. And there's nothing in the current guidelines that would make that a presumptive commit. I'm sorry, that would be presumptive consecutive sentencing. And there's nothing in the current guidelines that would make that presumptive consecutive. It would be permissive consecutive, but not presumptive consecutive. So that's the change.
Do you have any follow-up questions?
Yeah, it's extreme. This new statute or these new provisions, I will say, are pretty confusing. I guess I'm reading it differently, that it is, the language is that it shall be executed and run consecutively to the sentence that the court imposes an executed sentence for why they're in the jail.
Right. That's the criminal vehicular homicide in my example. So that the assault conviction, the assault sentence has to run consecutively to the criminal vehicular homicide sentence in this scenario. And that's what 6092232 clause B2 is getting at, as I read it.
Right. So in your proposed language, though, shouldn't it also include that part?
That's what we're trying to get at in the new draft that I did. It wasn't really that specific in the previous draft that we submitted to you in June. And this draft, I think, covers that in my new language, the new 2F1A13 is, as I've rewritten it now, is designed to cover that criminal vehicular homicide example. I don't think it really did that before, or it was really too broad.
Any other questions,
No.
do you think? Okay. I mean, this will certainly be something that all commission members will be taking under advisement and reading more carefully between now and our meeting next week. So I appreciate you bringing this forward and helping us to doing some work to try to help us clarify the impact of these new laws, Director Wrights. Any other questions? All right, hearing none. So that ends. Thank you so much, That ends your testimony. The question now is whether we have anyone else who is interested in testifying today. Not sure what the mechanism is. Okay. There was a couple people online that I don't recognize, so.
No one, so, Madam Chair, unfortunately, it's not enough to be online because it is required before testifying that you have to register with your name and contact information and affiliation. So we do need people to call the number or the email address that you gave the public at the beginning of the hearing. And right now, as of this moment, no one has called that number or emailed. And
Okay,
although a
so
number,
let me just give those again, and then as we have done in past hearings, we'll wait a couple of minutes to see if anybody responds to that. So just as a reminder, if you're interested in testifying today and if you haven't registered, please sign in with staff now. If you're attending remotely, please email your registration information to staff at sentencing.guidelines@state.mn.us and do that right away. And if so, if you do that, we'll get you in the queue for any testimony today. But we do not currently have anyone else who signed up, and we don't have anyone in the room who indicates a desire to testify today. So what we will do is we'll take a break from now until we'll just go to 1:25 to make it clean. And if we haven't heard from anyone by then we will go ahead and adjourn the hearing. So you're on break for the next couple of minutes. Thanks. All right, I'm going to call us back to order. I keep taking off my glasses, and I'm actually old enough that I need them all the time now. As nobody else has registered to testify, that concludes the business of today's public hearing. The record of this public hearing will remain open for 5 calendar days after today through July 22nd, 2025 to receive additional written comments. Please submit any additional written comments to the Commission's email address at sentencing.guidelines@state.mn.us. So that concludes the public hearing. We do, as I said, have a meeting next Thursday, a week from now, to finally consider adoption of this package of proposals that has been out for public hearing. So that is also open to the public and members of the public. There's always a section for public testimony at that hearing as well. So with that, the public hearing is adjourned. Thank you to all of the commission members who came out today. Have a good week.